McCrosky, and I work for United AP Counselors. I was a primary patent examiner for 8 years. I worked for the Patent Office for a total of 14 years. During my time as a primary examiner, I trained new examiners on these on many topics, but two of the topics that I trained were means plus function and patent eligibility, or abstract ideas under 35 USC 101. The medical device area is susceptible to the abstract idea issue quite a bit, and so my rejections were often appealed to the Patent Board of Appeals, and I had to write briefs and defend my rejections. Went to appeal about 8 times, and I won 5 of those 8 appeals. So what I noticed while I was patent examiner was different styles amongst the different countries and how they drafted their applications. The Japanese style would appear to invoke means plus function more often. That is, the Japanese style focuses the claims more on advantage and functional language, and whereas the examiner preferred style, and in fact more often the U.S. Patent attorneys, they write their claims a little bit more structure specific. So the examiner, he's supposed to review the patent application for whether the claims invoke means plus function by using this 3-prong analysis, and the 3-prong analysis can be found in MPP 2181. So the first section or first prong is, does the claim use the word means, right? Now it doesn't have to use means, and I'll get to that in the next slide, but it can use other generic words like portion, unit, system, assembly, device, part, member, mechanism, things like that don't specifically, when it's stated or written, it doesn't specifically invoke the idea in someone's head of what that actual structure member is. And the opposite would be lever. If you say lever, that's exactly, people will exactly know what that is in their head. But if you say a member, that could be a lot of different things. So the first prong is, does it say means? Does it have a generic word in it? The second prong is there functional language attached to that means or generic word? So, for example, functional language would be means for operating, right? So, or operation means for operating. So that's the second prong. Does it have that? And then the third prong is a little confusing because you're looking for the absence of something. So you're looking for the absence of, the examiner's looking for the absence of the structure or material that would be required for that generic to perform that functional language. So going back to my example of operation means for operating, if it also said including a lever, that would actually not invoke means plus function because there's structure there's functional language, yes, but there's structural language also, that lever that's being used to perform the function of operating. So let me go back one more. So the examiner is supposed to do this 3-prong analysis, and the examiner does not always do this 3-prong analysis and include it in the office action. So this is a way, if you would want to address the examiner's interpretation of means plus function, the practitioner can simply state, hey, the examiner did not perform the proper analysis that as set forth in MPP 2181. So here's the generic placeholders, words. I call them trigger words for means plus function. Just portion, unit, device, assembly, member, part, mechanism. These are all just generic words that over time have been associated with the word means, and when the examiner sees these words in the claims, they immediately will start looking for whether means plus function is invoked, hopefully using that 3-prong analysis that we just mentioned. So here's an example of means plus function, and invoked by the Japanese style. So the Japanese style, from what I've seen, is an example is using first plate portion, right? Whereas the US style is simply to drop the word portion. So first plate portion is broader than first plate, right? But it's also that, because that portion, because of that generic word at the end, portion, that's going to invoke the means plus function. So one way to avoid means plus function is simply to just drop the word portion, right? So first plate down there at the bottom of the US style, that's that word plate that invokes in the mind of one of ordinary skill in the art, a specific structural element, whereas portion is that generic kind of abstract, meaningless almost word. So here's another example where the Japanese style would be more to use first movable part, whereas the US style is to be more specific. So instead of movable, it's describing the movement, pivoting. So instead of simply saying part, it's describing what kind of part, arm. Right? So now you have the specific pivoting arm that is not invoking means plus function, right? Because again, the arm is a specific, invokes a specific meaning into one's ordinary skill in the art, whereas part is more of like the generic, abstract kind of idea, meaning. So, and the second way to avoid means plus function is to use a word that has a broader meaning, but yet isn't one of those trigger words that I showed before. So here's an example where the claim would say fixing part for connecting, right? So the fixing part is that generic word. For connecting is the functional language. But here, instead of just simply dropping the word part, here we're going to replace the entire thing with the word connection or joint. Now, so connection or joint, it's more specific than fixing part, but yet it has a broader meaning. It can encompass many different things: welding, brazing, gluing, glue, adhesive, rivet. So it's still, so you still have that breadth, but yet you're not invoking means plus function. So this is a second way to avoid means plus function. So here's a third way that's a little bit unusual, but I just wanted to bring it out and mention it because this is a way to do it. And sometimes this is a handy drafting mechanisms, but it's important to realize that third prong that I mentioned, that there has to be the absence of structure, right? So it lacks sufficient structure for performing the function as stated in NPP 2181. That's the third prong. So a simple way to avoid means plus function is to provide the structure, add the structure, so that there's no longer the absence of structure. So for the example here is operation part for operating. So again, we have the word part, that's generic word, substitution for means. For operating, that's the functional language. But here at the end, we just add the word includes a lever. Now it doesn't invoke means plus function because you have that structural term lever in the claim. So this is not necessarily better or worse than the other two ways. The first way being just simply drop the word part, and then the second way was to simply add a more over-encompassing word that doesn't necessarily invoke means plus function. This is just the third way, just an option that you can use. So here's another two examples, but here instead of a structural mechanism, structural term, we're using material words. So here, needle part for preventing infection. Need part, again, is the substitution for means, generic word. For preventing infection is the functional language, but in order to avoid means plus function, we simply add the word include stainless steel. So now that material that's used to prevent the infection is present in the claim, and so now, because of that, it no longer invokes means plus function. Final example here, damping member for absorbing vibration. Member is the generic word. For absorbing vibration is the functional language. Simply adding including silicone rubber, that's the material that's doing or performing that function of absorbing vibration. So this no longer invokes means plus function. So now we're going to go to, now I'm going to talk about eligibility and abstract ideas under section 101. It's important for the examiner to establish the full interpretation of the claim and understand the full breadth of the claim. How he does that is by determining not only what the words mean, but whether the means plus function is invoked or not invoked. So right here at the very beginning of section 2106 of the MPB, which is the part that governs determining eligibility and abstract ideas, claim interpretation affects the evaluation for eligibility. They have to determine, the examiner is supposed to determine the broadest reasonable interpretation. The examiner is supposed to determine whether means plus function is invoked. So here, this is a flow chart that's in the MPEP that the examiner is supposed to use when determining eligibility. Right there at the top, establish the broadest reasonable interpretation of the claim as a whole. Again, so this is where means plus function is important, is determining whether that is invoked and whether it has an effect on the eligibility, the abstract idea. So then moving down the flow chart, you have step one, which is to the claim to a process, machine, manufacture, composition, or matter. So those are the types of inventions that can be patented under 35 USC section 101. Interestingly, this section here, 101, this is almost exactly the same as it was written by Thomas Jefferson 200 years ago. So like, that's why we have all of this to begin with, is because this statute has not been amended to include these computers and software and that kind of thing. We're still dealing with this antiquated statute and trying to deal with how do all of these modern devices and computer systems and AI fit into this antiquated statute that Congress has still not bothered to amend. And so here in step one, you have again, process, machine, manufacturer, composition, matter. Software is not in that list, right? So that's why software per se is not patentable, is because it simply does not fall into one of those categories, and therefore under the law it can't be patented. So then the examiner moves to step if the claim is directed to a process, machine, manufacturer, composition of matter, then the examiner will move to step 2A, which is the claim directed to a law of nature, a natural phenomenon, or an abstract idea. So today I'm not going to focus so much on step 2B, I'm going to focus on step 2A. Within step 2A, as if it's not complicated enough, there are two prongs within step 2A. There's prong 1, prong 2. Prong 1 is, does the claim recite an abstract idea, right? And then prong 2 is, does the claim recite additional elements that integrate the traditional exception into a practical application? So taking it one at a time, prong 1, does the claim recite an abstract idea? Again, as if it's not complicated enough, there are three groups of abstract ideas that the claim must fall into in order to be considered ineligible. One is mathematical concepts. Mathematical concept does not mean a formula in a claim. I mean, it can. A formula in a claim is definitely a problem, but it can be something that's described in words. It could be using statistical words or statistical analysis. It could be simply saying if the first data is greater than the second data, open up the lid, that kind of thing. It can be described in words. It can be simply greater than, less than. Organizing human activity, examples of that is writing contracts, creating a schedule or calendars, something like that where it's helping a human activity. Mental processes, this is one that I often saw in the medical device area because I was dealing a lot with computer diagnostics. And diagnosis in US patent law is considered a fundamental building block. and that's the whole point of this eligibility thing, is that they do not want fundamental building blocks to be patented. So diagnosis is considered a fundamental building block, and it's also considered a mental processes. You know, we do diagnosis all the time, we don't even realize it. Like we pull up, we're driving along, we see a stoplight, and we're diagnosing, should we stop, should we keep going, should we, you know, take caution and take heed of the yellow light, right? So like that kind of mental processes where are you comparing one thing to another and then making a decision, all those kinds of simple mental processes that we do every day, the patent law system in the US wants to avoid patenting those things, and unless it's integrated into a very specific set of industry and laws and rules, and I'll show that to you here in a second. So these are 4 ways that the claim can be drafted or such that the claim can be eligible. In other words, it no longer is simply reciting an abstract idea. So the mental process that I mentioned before, like diagnosing and that kind of thing, or even a mathematical formula or operation, that has to be done practically in the human mind in order for it to be considered ineligible. Something that's not practically done in the mind, a very large mathematical operation, a large formula, taking in a lot of data, that sort of thing, that is not practically done in the human mind, and therefore it should not be considered an abstract idea. Specific processing. Not most claims that get in trouble with abstract ideas, they simply say processor or control unit or something like that. But if the claim is specifically stating some sort of neural network, some sort of artificial intelligence, and explain the details involved with that processing via the neural network, artificial intelligence, that is not supposed to be an abstract idea. Now, some examiners will still reject that, but there's case law that says that's not supposed to be an abstract idea. Tailored to a specific industry, so the example I always use is, if the claim says something like the first sensor sending data to turn second unit, right? That's not enough, right? That's very generic. But if you're saying the first sensor attached to the transmission to detect whether the wheels should spin, right? That's much more specific. That's tailored to the automotive industry, and that's the specific industry, and that can help with getting around the abstract ideas. Finally, the specific improvement in the technology. That is this combination where it needs to be both supported in the specification as well as in the claim, and it has to be in the abstract idea itself. So the computer program. So if there's an improvement, if the attorney is arguing that the improvement happens outside of the abstract idea, that's not going to be considered an improvement in the technology. So an example of that would be a computer diagnosis is made of a patient, and it's determined that the patient needs medical help. So that right there is the abstract idea. And then there's this output feature where a notification is sent to the doctor because the patient needs help, right? That notification part, many times as an examiner, I would see arguments from the attorney that this notification part, that output, was an improvement in the technology. However, the case law says that it has to be, that output is not an improvement in technology. The improvement has to be within the abstract idea itself. It has to be describing what is it about the diagnosis that's different. How does it improve the technology of the computer diagnostics, medical diagnostics? So that's something that to keep in mind, is like it has to be, that improvement has to be within the abstract idea. You can't rely on input or output to be the improvement in technology. Here's an example of a application that I examined when I was an examiner. This is a Japanese application company. This is called NTT. And so if you can see, it's a little confusing, but the amendment, if you compare what the claim looked like before the amendment and after the amendment, before the amendment, the claim was reciting mathematical operations that I had determined could be done practically in the human mind. So I rejected it under section 101. They came back and they added more detail to the mathematical operation. So that mathematical operation that's highlighted in orange, that's what they added. As you can see, that's much more complicated. I determined that that was something that couldn't be practically done in the human mind. And so I withdrew the 101 rejection and allowed the claim. So here's an example of what I often saw on the left with ineligible claims. And on the right is an example of an eligible claim. So on the left you have a sensor, some sort of data gathering device that's inputting data into the computer. The computer's performing some sort of analysis, some sort of comparison, diagnosis, some sort of what would be considered a mental process. And then it displays the results. There's this output. So what I often would hear from the attorneys is, well, first of all, this is not even reciting an abstract idea. These are physical elements. This is a sensor. This is a computer. This is a display. Like, how could you possibly say this is an abstract idea? This is the case law, right? Like, this is based on the case law. On those, from a, what do I say? It's just strange, right? Like, it's just strange. Like, these are physical devices, right? Like, how could this possibly not be patentable? Right? But the way the case law is now, these sorts of things are not patentable if the computer is doing something that's simply diagnosing or comparing, something like that. Even if there's a sensor feeding in that data, inputting the data into the computer, that's not enough to bring it out of the realm of ineligible claims. So what needs to be done is that abstract idea by itself needs to then be applied to something in the real world. So here on the right you can see, again, the same thing. Sensor, computers have performed some sort of analysis as an abstract idea, but instead of simply outputting it, the analysis on the display, an action is taken, right? So here there's a calibration unit here, a feedback loop, where the sensor at the bottom is adjusted. So the sensor at the top, is adjusted based on the abstract idea, the analysis performed by the abstract idea. Another example that I saw in the medical device area would be there's a glucose sensor to determine the blood sugar of the patient. That data is fed into the computer. Computer performs some sort of analysis, compares greater than, less than, all in some sort of mathematical operation or diagnosis. And then instead of simply displaying it or sending a notification or an alarm to the doctor or whatever, then they would the computer would instruct a pump to then administer insulin or some sort of medication to the patient. That sort of real world application is enough such that the claim is eligible for patenting. There's no problem with the abstract idea. So that's all I have. I know that was a lot. Does anyone have any questions, or do you want me to go back to another slide?
So since I'm not a patent guy, I have a question. So you mentioned some trade-off words. Those words are examiners see, oh, that might be a means plus function, but not always. Like as first it's specified or added, like inclusive, silicon rubber. But conceptually it's hard because something including silicon rubber. To me, what's the difference? Because like membrane and including silicon rubber, Because membrane, if you end with the word membrane, it might be broad, too big. But if you add it, including silicone rubber, including means you may cover other membrane, but still it gets clear, right? In U.S. practice.
Yeah, and so that's another reason, or that is one advantage to that third option that I gave, where you can have that structure, is because it says includes rubber, right? But as you said, there could be
Like
50 other types of materials also, right? So, but yet, it says that rubber can be used to perform the function in the claim, and it takes it out of means plus function. But you're not completely limiting it as much as if you simply just get rid of all of it and say just silicone rubber for
to search and satisfy or clarify some what can be the membrane or something.
Right.
But, excuse me, just to take advantage of this example put forward by Koji. According to my understanding, membrane would not be considered a generic placeholder.
True.
Because membrane is already specific.
Yeah,
It's
so
clear
maybe
what it
maybe
is. So it would not be a generic placeholder. So generic placeholder in the examples provided by David could be like a device, structure, element,
membrane member.
unit, maybe,
Yeah.
maybe unit.
Membrane means. Yeah.
Yeah. So
for example, I have some moving unit, and there are some example. For example, it's pivoting arms, or there's a mechanism that using some wheel or something. There are some two or example of the moving part. In that case, I think mean plus function advantageous, because that means plus function includes its pivoting arms and some other mechanism to do something. Yeah, is it true or not?
Sure. Yeah. There's nothing inherently wrong with means plus function claims, right? Like you're free to use means plus function, and they were created. The means plus function claims were created for a reason, right? Because sometimes it's better, it's simpler and sometimes it's really the only way to describe something, is by the function, and so there's nothing wrong with that. You can do that. It's that often they don't want, practitioners don't want to get caught up in the means plus function analysis, whether it's at the patent office or if it'll go to litigation, because then you have to re-litigate and rehash out whether it invokes means plus function all over again. And so, but it's just a choice of the practitioner. If you want to use means plus function, that's great. It's fine. And then there's also the option of doing both. You have a set of 10 claims that invoke means plus function, and then another 10 claims that don't invoke means plus function.
Okay, thank you very much.
One request came up online. Some of the clients say you have a feature in process.
excuse me.
The process, like
Okay.
manufacturing process.
Okay.
But they do not want to protect manufacturing process because it's not easy to enforce.
Okay.
So they try to protect their invention as a material. So when they try to seek that such protection, usually in Japan, means plus function are like sometimes used to talk about feature of the actual product. So as you mentioned, if there is specific, like there is no other way to describe, it's okay, but we have to think about how to overcome.
Yeah, or not. It doesn't. You don't have to, right? So and sometimes the examiners will act like means plus function is wrong, there's no such thing as a rejection under 112 section F, right, like, which is the means plus function part of the statute. Like, it's just simply an interpretation. And even the interpretation that the examiners set out in the office action, that's just their opinion. They're required to do that. They're required to set out, make the record clear. Here is how I'm interpreting the claim. But that doesn't mean that a judge in the federal court will necessarily agree with them, but agree with the examiner. And the judge at the federal court is supposed to do his own analysis. He's supposed to start from the beginning. They call it de novo. So he's from the beginning, he's supposed to do his own analysis and determine whether the claim invokes means plus function. He's not supposed to just look at what the examiner said and go, okay, the examiner said it was means plus function, so it's means plus function.
But maybe may I make a comment on that? According to my point of view, because we are patent attorneys, we are counselors. So when the examiner invokes that means plus function analysis, we have the duty towards our clients to explain that, and like, if of course if the client says, I'm okay with the means plus function interpretation, I'm okay with that, okay, we are all but the problem is that, at least this is my point of view, if I feel kind of obliged to propose to the client some kind of a strategy to avoid that interpretation, because that interpretation is normally more narrow than what the client originally expected. Because if you used, when you drafted, you used means plus function, is because the client expected to protect the broader range of things. Then when the examiner says, look, I interpret this restricted to the first example I find in the specification, when you inform the client about that, you normally feel that you have to propose him a strategy to avoid that. But of course, if the client is okay with that, we are all happy. Right? So this is why, I think, this is why normally attorneys, and I'm one of those who wish to avoid that, and my colleagues can testimony that when they at the beginning, when they were hired, I kind of trained them, okay? And I trained them to try not to use means plus function structure when they drafted the claim, even though in Europe it is accepted as much as in Japan. But when we go to the United States, it's very annoying, because you need to reward the claims, you need to explain the client, and it feels like you feel like you draft it the wrong way. Because, okay, the first time is okay, but the second time, the client may say, okay, but if you knew about that, why? Why do we have to, are we receiving this objection over and over? Can't you just fix it beforehand? This is why you normally have at least, okay, well, there has been a period of my, say, working when I drafted means plus function, and then I rewarded the claim just for the US. But then I got tired of that. I got tired of having to fix the claim every time. So now we changed the approach. We try to draft the claim since the beginning with the US approach, because my personal view is that, as also David explained, many times the US approach, let's say, allows the same breadth or even broader. Like if you say a heater, you cover every type of heating means. So there is no reason to say means for heating if you can write the heater. It's just a very simple example, right? David, was that sort of a
Yeah.
the first example you provided with the
With the
the
heater?
joint,
Yeah, the connection.
the
joint,
connection, the connector
Mhm.
or joint instead of connecting means, right?
Right,
It's-
right, right. Yeah, and
So-
there's still some breadth there, right? Like, because it can mean it could be screw or bolt, rivet, like some things. Yeah.
So many times it works, but sometimes we also receive the objections,
Mhm.
not for the means, but for the unit, maybe. Yeah.
Just I'm curious, so yes, say Japanese clients are familiar with this practice. So when we receive Office Action 101, how they react? They think, oh, yours, or you should supposed to know, or you are expected to own.
いや、多分お客さんによってはもうそれが分かりきってることもあるし、はい、もうワンワンのことですか。
101、これの拒絶利を受けたら、
よく聞きます。
いやだからそれしょうがないもんと思ってるのか、いやこんなのアメリカ分かってるやん、先に配慮しといてよっていう、それはどっちも。Both. I asked how like the client say, oh, 1-1, okay. But the other people may think we should have added or edited something to overcome 1-1 in advance. So he goes, we have both clients.
Can I make another comment? But I asked David's confirm. Well, according to my understanding, the difference between if you use means or you use unit, for example, is this, that if you use means plus function, by default, the examiner will apply that interpretation, okay? And you are supposed to know, according to my opinion, you as a patent attorney. If you use another generic placeholder, like unit, the examiner may object or may use that interpretation, but he has the burden, it's to explain the reason why. He has to provide an explanation, a proof of why he uses that interpretation. So it's a little, so it is acceptable for me to receive that objection from the examiner because it's like the unity of invention a posteriori. If you draft a set of claims which is unitary, okay, you did okay, but if the examiner challenges the novelty of the independent claim, at least in Europe, okay, and then he has discretion to raise a unity of objection. In that case, you cannot decline. The client should not blame you because that can always happen. It's at the discretion of the examiner. But at least, in my opinion, you should avoid means plus function because you are sure 100% that he will apply that and you will be called to fix it. This is my personal view, but I don't know. David, does that make sense?
Yeah. So I mean, if unit, all of those are trigger words. Means, the word means is most definitely a trigger word. Right?
Too obvious,
Yes,
obvious
yeah,
word.
Right. So, yeah. unless you just want means plus function, then go ahead and use means. Right? That's fine, you know, that's great. So, but like, if at least with the without means, then they have to do this three-prong analysis. And they determine, you know, whether that word is generic or not. And then, there's always exceptions. I don't even know if this is relevant, but you know, so if it said operation means for operating includes a lever, that wouldn't invoke means plus function, even though it's using the word means. That there's still structure there. I mean, like, this is hyper-technical exception kind of thing, you know, right? But so that, I mean, there are ways for you to actually use the word means, and it still wouldn't invoke means plus function because of the structure, right? The third part, in order for means plus function to be invoked, that there has to be three parts. That third part is there has to be the absence of structure, right? So structure and material. So, but yeah, but generally, yeah, I agree with Mark.
Because in that case, it would be the same as saying lever.
Yeah, yeah, true. Yeah.
Lever.
A lever for operating.
Yeah, or, yeah.
Yeah.
So we include the operation part. So except the lever. So for example, a lever or steering or a pedal. So it is okay.
Yeah, that's okay. And that would not invoke means plus function.
I think in that case, I don't need some include some lever or something. Just say operate something unique configured to blah blah blah. Is it enough? I think if there are some plural example of that unique.
It would. So you're stuck with what's in the claim, right? So but if it invoke means plus function, then they go back into the specification and determine what your examples are.
Yes. And in the field of computing, I have to write at least a part of the claim. I have to write the function. Yeah. In that case, a processor configured to some operations. In that case, what the structure of this?
What, I'm sorry, what was it?
It's a processor configured to some operation.
Yeah.
Yeah. And in that case, what is the structure of that function?
Right, because it's all performed in the computer.
Yeah.
Yeah. So in that case, it's just the computer itself, right? Like, so I mean, if it's the processor, processor neural network, that kind of thing. That's going to be a structure. I've seen American attorneys use circuit. So instead of processor, they'll say processing circuit, and because that circuit is not a trigger word, that's a specific structure.
Right.
It's no longer means plus function. So I've seen that before. But generally, like, a processor by itself should not be interpreted as a means plus function. A processor unit, a processor system, something like that would be interpreted as a means plus function. I can't promise you that an examiner is not going to declare that the processor invokes means plus function by itself, but generally it should not.
Excuse me, in your example, the one you just provided, I was thinking on the same example, but I was more worried for the other topic that David presented, the one-on-one rejection of ineligibility, because if it happens that it happened to me recently, I had a case for a client where they protected a system which is sort of a chatbot, with artificial intelligence behind for allowing a user of a machine to get help. So when a user of a machine has a question, has a problem with the machine, instead of calling the assistants, he writes a question in the chatbot, and then the system automatically provides a technical assistance. So that was and I received an rejection under section 111. So now I was thinking, if I have that everything is actually performed by software, the structure is the computer and the memory, and that's it. The processor and the memory, that's the structure. So all we can do is in order to put more, be more specific, is about what it does and how
And
it is done.
the improvement.
The improvement in terms of
technology. Yeah.
what is actually, what calculations or
Yeah.
steps are performed,
The specificity.
because otherwise there is no structure that you can put there, right?
Yeah.
Yeah.
Yeah, so yeah, tailoring it to the industry, the chatbot, and then adding that improvement in the abstract idea in what that computer is doing, that's probably your best bet.
And maybe trying to argue that what is actually done is so complicated that it could not be practically performed by the human
Yeah,
mind.
absolutely. Yeah.
Yeah.
But in fact, example, I think EP is also difficult to get patent because of the inventive step issue, I think.
Oh, Europe is a different story.
I know.
Yeah. You are right. In Europe, everything is shifted to inventive step.
Yeah.
Yes, I agree. In Europe, the claim, David, can you please go back to your example with the sensor?
Mm-hmm.
The claim on the left in Europe would automatically go over the issue that in Europe is Article 52, which unpatentable subject matter, which would correspond to ineligibility. You do not have any problem because the sensor computer are technical, and therefore you do not have that problem in Europe. But the problems are shifted to inventive step, as you said, yes. Because if the contribution, so to say, in Europe the examiner would say, okay, if these features are non-technical, in the inventive step analysis, I will disregard these features, and that can be a problem. Yeah.
Thank you very much.
Thank you.
Any questions?